Okay, welcome everybody. We're going to go ahead and get started now. I'm going to share my screen with you. So if you're not familiar with us, we are with Ridge and Downs. My name is Amy Lee Hogan-Simonovich, and my co-host today is Karen Connolly. Karen and I concentrate our practice in the area of workers' compensation litigation throughout the state of Illinois. And our firm also does other types of injury law, as well as fee law, which is railroad injuries. So we're, while we are available to answer questions about any type of injury, we're here today and you signed up to learn more about the COVID-19 presumption. The Illinois legislature has prepared an amendment to the Illinois Occupational Disease Act. We do expect it to be signed into law by Governor Pritzker shortly. So we want to make sure that before it becomes official that everyone knows what's going to be happening. Okay, so I went one too far. So the first thing is why you would want your COVID-19 condition to be considered work-related. And so we're going to talk about the basic rights that the Illinois Workers' Compensation and Occupational Disease Acts provide for injured workers. The first is the right to medical treatment. So you can get those medical bills paid, especially important if you've been hospitalized for your condition. You've got some big medical bills, right? The second is the right to payment of weekly benefits while off work. So while you're unable to go to work for recovery from this condition, you want to make sure that you are paid, under PETA with your regular salary as if nothing happened here. And you want to make sure that you're able, to provide for yourself and your family. So another really important benefit. The third benefit is the right to permanent partial disability benefits. And what that means is that you're entitled to a settlement or award for the residual effects that this condition is going to cause on your body. And the science is kind of, still developing. This is a very new disease and everyone's recovery can look different. But we want to make sure that if you do have residual effects in the future, that you're able to get that taken care of as well, and be compensated for that. Okay, so Karen's going to go over a little bit of the basics of what you need to prove for a work-related claim.
Under either the Workers' Compensation Act or the Occupational Disease Act, there are several things that you have to be able to prove, COVID or non-COVID, in order to be successful. First of all, you have to prove that an accident occurred. A petitioner must prove that an incident happened that arose out of it in the course of the employment and that there's risk associated with the employment. With respect to causal connection, that really means that the accident has to have a relationship with the condition that the injured party alleges is keeping them off of work or causing them to require medical treatment or has resulted in their permanent disability. Lastly, you have to prove that you had lost time if you lost time from work, or you have to prove that you had permanent disability if you want to prove entitlement to those benefits.
So what the legislature has drawn up is a provision that provides that if first responders and frontline workers contract COVID-19, there is a rebuttable presumption that the disease is related to their employment. The presumption applies to both the accidental exposure and the causal relationship between the exposure and the employment. That's a pretty strong legalese for everybody. So Karen's going to go ahead and explain for us what a rebuttable presumption is.
Rebuttable presumption is only, it sounds fancy, it's not. It's an assumption of fact accepted by the court until disproved. So in this case, the legislature has passed legislation where they're assuming that if people that are in particular categories get COVID-19, that it was both an exposure related to their employment and that exposure is causally related to the injury. It can be disproved by the employer. They have the opportunity to present evidence to take someone outside of that presumption. What the presumption is not an automatic. If you fall into one of these categories and you have COVID-19 or are diagnosed with COVID-19, you automatically receive the benefits from the Occupational Disease Act. What it actually is a very strong help up to meet the requirements that are legally necessary in order to prove a case under the Workers' Compensation Act or the Occupational Disease Act. In this case, the language is very strong and it's a huge help up, but that's really what a presumption is.
Okay, so let's talk about the categories of people that are covered by the presumption. There's two distinct categories. The first category is what's considered first responders to the pandemic, and that's going to be police, fire personnel, emergency medical technicians, paramedics, all individuals employed as and considered first responders, all workers for healthcare providers, including nursing homes, rehab facilities, and home health care workers, as well as corrections officers. The second category is frontline workers. Those are as described in Governor Pritzker's executive order from March 20th of 2020. And that is a very broad category of people in human services, essential infrastructure, essential government workers, store workers, drivers, food and beverage, media. So a very, very broad swath of the population. And so what is important to narrow that category down is that these individuals are required by their employment to encounter members of the general public or are required to work in employment locations of more than 15 employees. Now, there's three general types of evidence that an employer could use to rebut this presumption. The first is that the employee was working at home or on leave from the employment for a period of 14 days immediately prior to the injury. And in other words, the question is, did you go to work within the 14 days prior to your injury or condition? The second type of evidence that an employer can use to rebut the presumption is that the employer was engaging in and applying to the fullest extent possible or enforcing to the best of its ability industry-specific workplace sanitation, social distancing, and health and safety practices based on CDC, Illinois Department of Public Health guidelines for at least 14 days prior to the injury or exposure. So what you're looking at here is when you come down with COVID, depending on when that was, we have to look at what the guidelines were at that particular time. So if you had COVID already in March, it's not going to matter what the guidelines are right now. We have to go back and look at what recommendations, industry specific, were being made at that time. And finally, the employer can rebut the presumption by showing that the employee was exposed to COVID-19 by another source. What we're looking at here is maybe you attended a party, attended a barbecue, maybe you went on a little trip, maybe your spouse had symptoms first, suggesting that they were the ones that actually brought it home. It's very common for employers to be aware of their employees' extracurricular activities. This is mainly seen through social media, as well as our clients, from small towns or that work in small towns, that everybody kind of knows everybody's business. So just something, to be mindful of as well in thinking about kind of what activities you are participating in outside of work if you're in a high risk employment. Karen?
The legislature also set up some rules that apply to the presumption regarding COVID-19. The first is that the presumption is only going to be from March 9th, 2020 through December 31st, 2020. So at this time, if someone is diagnosed outside of that time frame, the presumption, they're not able to use that presumption regardless of whether or not they fall into the applicable category. The second rule that was set up is that if you are diagnosed before June 15th, that diagnosis can be confirmed by a medical professional or a positive laboratory test or antibody test. After June 15th, the diagnosis must be confirmed by a positive laboratory test or antibody test. Our understanding of this is because the testing, especially in March and April, was so limited that people were getting sick and they weren't able to be tested, so they weren't able to have that official confirmation by a test. The law isn't limiting you from being able to receive benefits under the Occupational Disease Act. That medical diagnosis is sufficient. It's also very important to remember that for people who don't fall into those categories, either the frontline worker or first responder, or if the presumption fails because your employer is able to provide evidence that rebuts that presumption, you still can have a case, you still can win your case, you can prevail under the Workers' Compensation Act or the Occupational Disease Act. So please don't think that because you will fall under the presumption, but maybe your spouse doesn't or your friend doesn't. They can still receive benefits. We just have to prove their case the same way that we would have to prove any sort of Workers' Compensation or Occupational Disease Act claim.
So let's talk about what we need to prove a case. Now, whether we're doing it with or without the presumption, these are the things that we're going to be looking at. The first is, it is very helpful to be able to show evidence of work-related exposures. Now, what we're talking about here is if any inter-office or inter-department memos have gone out saying, your coworker was positive, we're notifying you that someone in your department or division has been diagnosed with COVID. You have that document so that you know that you've had exposures at work to those coworkers, right? Also important, if you are on any calls, if you are responding to any incidents that the individuals in the community are experiencing COVID symptoms or are COVID positive. So something to keep in mind in terms of not waiting until you get sick to get that information together, but maybe keeping some notes or keeping a log, keeping a handy folder with those things so that you're not scrambling to find them if you are unfortunately diagnosed with COVID-19. Karen, did you have any other suggestions on that first one?
I guess I would just add that, I know a lot of the people that are listening are union involved. So if it's a possibility for someone in the union hierarchy to keep track of the memos, to keep track of the notes, that would be really helpful to your members. I would also add that I know that my community has just passed, I believe, an ordinance where they're advising the police and fire departments of the address of people who test positive. I don't believe they're giving the names, but I imagine that comes out in memo form, or there's something that says, okay, now there's 15 people in the community There's, I follow the Twitter from my police department. They, every couple of days, will say there's someone new in our community, there's someone in the community next to us. So I imagine that there's all kinds of statistics and things that are being published that you have access to. So keep a copy. It's, you know, that's important, and that's important to your members.
The second piece of evidence that we're looking at is your medical diagnosis, your test results, your doctor's visit notes. So, you know, copies of your positive COVID or antibody test. And then when you go to the doctor, you should always leave with some type of work note in terms of whether you can or cannot work in order to support your entitlement to benefits for your time off of work, for your recovery. You do need to have a doctor's note to support that. And then finally, we talk about kind of proof of permanent disability, if any. And what's important to keep in mind here is that, for example, if your recovery proceeds well, you're returned back to work, but you go out to respond and you know, are chasing a subject and you notice that you're way, you know, more out of breath than you used to be, you're having trouble breathing. Any residual effects that, you know, you weren't anticipating that pop up, you know, you need to make sure that that's something you're documenting, you know, with your doctor, so that it's something that, you know, should it progress or give you trouble in the future, you know, is documented in the doctor's notes. So,
and please be aware that no one really knows what the permanent effects of a COVID-19 diagnosis may be at this time. So your members or anyone that you know that's diagnosed really needs to pay attention to what is different with themselves, because people have, just the few people that we've spoken with over the last, you know, month or so have had a number of different and some of them kind of unusual effects as they recover. So please make sure that it's not just shortness of breath. That's probably the main thing, and that's probably the most common, but there can be all different sorts of residual effects. So if people know to pay attention to that, it can be real important in proving that there is permanent disability.
okay, so that concludes our slide presentation. I've included email addresses for Karen and I, as well as our phone number at the office, our website. If you go to our website, there's also an area where you can sign up for our e-newsletter. We send out updates about changes that occur in the area of workers' compensation. We also have a Facebook page where we also do that. We put any alerts or anything that interesting going on in the area of injury law, as well as different things that, you know, we're up to in the community, especially if you like looking at cute dog pictures, because we sponsor a guide dog, and I love posting pictures of Demi, our puppy, right now. So if anyone wants to follow us at Ridge Downs on Facebook or Twitter, we would appreciate that as well.
I would add to that we're very happy to do this presentation for any group that asks us to. We are more than happy to, you know, do it for your own group, do a virtual union meeting if you have one, or when all of this clears up and it's safe to go back and have meetings again. We're always very happy to come and talk to you about workers' compensation or anything else you'd like to talk to us about. Please, if you have any questions regarding any of this, please feel free to ask. We're happy to answer them, or any workers' compensation questions.
Does anybody have anything for the Q&A, or you can raise your hand? I was just going to give it a second in case we've got anyone.
Or any comments about what you're finding in your work site with COVID-19. We'd be very interested to get some feedback about what people are coming across.
We have a question from the audience. I work as a probation officer, 1 week at work and 1 week from home. Would I be covered?
I certainly think that you are covered as a first responder. I think that that you qualified probably under a couple of those different categories of first responder. And they can't use the rebuttable issue that you haven't been to work in 14 days because you're working 7 and then off 7 or 5 and then 5. So you're going to be there. I think that there's a very good chance we would be able to use that rebuttable presumption to help you or your members if they were to contract COVID-19.
All right. If we don't have any more questions, we're kind of right at that half-hour mark. So thank you, everyone, for joining us. Please, you're going to get an email with a link to the recording of the presentation. So if you found this information useful, feel free to share it with your coworkers or family and friends and other people in your life that you think may find it interesting. And don't hesitate to reach out to us if you want us to do another presentation or you have any questions that we can answer. So thank you. We really appreciate you spending a little bit of your time with us today.
Thank you very much.
Okay. Thank you.